Oh, shoot. Says you live.
Live. Legal priority status. Here we go.
Here we go.
Massachusetts Cannabis Heist, Colorado 6.
So we're doing a different format here just to make it real clear and explicit breakdown of exactly what it is we're talking about with this illegal priority status.
Yeah, this is our second time doing this video, but we might need to do it several more times. But just to relay the simple message of the illicit priority status. So here it is. My wife and I made the claim, but we actually pulled out the video where I think it was Doyle. Doyle made the claim of the legal priority status. We're going to go through that, and none of the commissioners contested it. And the actions that had it going on. This video, October 19th, shows that they all agreed to stop it.
Yep. So we're about to share that
while we're about to go through this video.
Let's see how this is.
And hopefully it should be clear and everything else like that.
So this is the video they want to do. Let's see if we can do full screen layout. I'm going to play this for you all. All right, we're going to pause right there and highlight two things that she said. A couple of key things that Commissioner Doyle said in this in that snippet. First is the fact that the CCC recognized something was amiss because, as she said, the RMDs were enjoying priority status. And to give you a bit of context, this meeting is happening in October of 2019. Licensing has been opened in Massachusetts since April, July, depending on if you have priority status or not, 2018. In over a year and a half time span, only RMDs are coming through the pipeline. And that is something that they recognized as them enjoying this priority status when economic empowerment certificate holders who also have priority status were not coming through the pipeline at all. So while she doesn't say that directly, the implication is there in the way that it's framed. And
let's let it go on. Let's let it go on.
Okay. Actually, I'm going to share it in a way that we can have both of ours.
Let's let him make him plain, like the old Baptist preacher used to say. Let's let him make it plain. Hold up. Let's not interpret the word. Let's read the word how it is. All right. Let's let it say what. All right, stop there. Elaborate. Do you want to elaborate on DPH? She said it right there. The concept, you had to be operating and dispensing, and you had to have gone through a process with DPH by a certain time. So all of these. So she's saying right now, her concern is with these RMDs who weren't operating and dispensing, hadn't gone through DPH by this time that they said they had to be going through it in legislation, and they had they are benefiting from this priority status and this open door. We need to shut it, guys. It's look how many people was on they talk numbers.
Yep.
It's this open door. We need to shut it, guys.
So yeah, they talk numbers, and towards the end of this clip that we're sharing with you, the second piece that I wanted to highlight in the her introduction to the dilemma that she says, and then it's reiterated here in this this segment, is the fact that she said that throughout the commission there was not a consistent understanding of the priority status, and when you have an agency and you have staff members who are really driving the work, it's incumbent upon the leadership to make sure that the staff understand clearly what their charge is, what the regulation says, and what the legislation, what the statutes are. And what she is saying is when she looks at the statute, which we may be able to pull up for you guys here and show that exactly to you. When she looks at the statute, the interpretation is that this priority status for RMDs was supposed to be for those who were operating in dispensing, so that because they have already gone through the process with DPH or their medical license, so there was no need for them to resubmit.
In that process,
resubmit the application. So one of the things I'm just going to highlight is a screenshot of where this concept is even coming from.
They can see that?
I'm going to share that.
Okay.
So let's do a quick share screen, and we can do share your entire screen. Let's see how that looks. There we go. And it is, let's see, now that looks crazy. Hold on. Let me stop that. Share it again so that you can just focus in on that particular screenshot. You can still hear what we're saying. And this is a screenshot of Massachusetts general laws. If you type into Google Massachusetts general laws, chapter 55, section 56, this comes up. It's not highlighted. Of course, highlights are just our notes. But here it says basically gives direction to the Cannabis Control Commission as to how they are to prioritize reviewing and licensing decisions for applications for retail, manufacturing, and cultivation licenses. It says in the section I that though priority will be given to those who are registered marijuana dispensaries with the final or provisional certificate of registration in good standing with the Department of Public Health that are operational and dispensing to qualifying patients. Several key things to point out. This is for entities that are already operating and dispensing. That's something that you hear us saying consistently. But the second thing to point out is these are folks who have had their application, their whole entire business vetted to the point of good standing with the Department of Public Health. Now, the Department of Public Health no longer oversees Massachusetts cannabis industry, whether it's medical or recreational. That was transferred over to the Cannabis Control Commission. And what this legislation here says is that when this transfer was happening, to prevent these dispensaries from having to go through the process already, when they've already been vetted by DPH, they will get priority in terms of having their paperwork reviewed. And that's what Doyle says in the clip that we just shared. So let's continue as she goes on. We'll reference this section again. Particularly, this section that is not highlighted here talks about the economic empowerment folks who also hold priority status. And the green section here talks about the time frame, because you'll hear at the end when Doyle is making a recommendation, she references April 2018. This is coming straight out of the law, out of state statute from 2017. So with that, we're going to close this out. And we are going to get back to her explanation in the video clip. Feel free to share. There we go. I'm pausing right there, but I'm not going to shift the screen. If you didn't catch what she said, there was in statute, there was a clause that basically said if the CCC didn't implement their regulations in time, all these medical dispensaries wouldn't even have to submit an application. If you were operating and dispensing in the medical capacity in Massachusetts, you automatically can open up a retail. However, they did, and that was the little chuckle that they had there, they did pass it in time. They did pass their regulations and open up the process in time. And so that means that those medical dispensaries that qualified for the priority status still had to submit some form of application in order for them to open up recreational. And so these little details are important in understanding when we say that outside of the people who should have qualified, which are just the operating and dispensing dispensaries, everyone else, every other entity, all the other RMDs that enjoyed priority status, it was illicit. It was ill-gotten. They should not have had this. All right.
Pay to play.
So that was my view of what the intent of the legislature was. It was not perfect, but I believed that the idea was that priority status was to enable entities that were already to be able to.
You want to comment on that? So that's a nice way, or a politically correct way to say she interpreted it as RMDs who were well on their way, pretty much RMDs who were already operating and dispensing, not RMDs who were coming in, paid to play, never opened up.
And when you say pay to play, there are fees that are several times higher to get a medical dispensary license. And those fees are significantly more than to get a recreational license.
And it was pretty much, hey, you come pay for the medical licensing and fees.
Yep.
You can open up, and you don't even have to open up medical. And these guys were able to come in through an imaginary priority status that the CCC imagined that they had, and came in through that avenue.
So to carry that logic through, in my mind, should be limited to locations that have a provisional requirement license.
All right, pause right there. There it is right there. She said it again. You understand me? She said it again. Her interpretation were for those that were already operational, already had a final license, not those who will say, oh, hey, I want to go to Massachusetts. These were folks who hadn't even thought about Massachusetts. The priority status was held open for 2 years almost.
Yeah, it was something to the tune of 590 days.
So it was pretty much, hey, once they got this solidified, this bottleneck solidified, they went to their rich buddies like, hey, we can get into Massachusetts. Their rich buddies in Canada, hey, we can get into Massachusetts. Well, I'll think about it. And thought about it for 2, 3 months, 6 months. Say, hey, let's go to Massachusetts. And they paid for the priority status. They weren't operating. They weren't dispensing. They weren't paying taxes in Massachusetts. But they cut the line of the Massachusetts residents. To the tune of 100+. They lifted an entire cannabis economy. You understand me? Through this avenue, through this illicit priority status, through this pay to play priority status.
And I think the point to also highlight is when we talk about the Colorado 6, when we talk about the key players who benefited significantly from this, Forefront Ventures and Vicente Sederberg, and how they were able to facilitate their clients into capitalizing on this illegal priority status.
After writing on our legislation, it's funny that Doyle made that distinction. She wanted it to be clear that she had no part, she did not partake in writing on this.
The legislation, she wasn't part of, she is interpreting the law as it stands and is presented and basing her understanding of what the intent is from the sections that we just highlighted to you. And so yeah, exactly like you're saying, she's making that distinction that she wasn't a part of drafting the original ballot or the revisions that our legislature made to ensure that Massachusetts businesses and residents are the ones who held priority status. So we are going to, I'm going to continue. Okay, great.
Priority status of a particular location expired, that company would not be entitled to priority status for that location.
That's interesting because we know a company whose priority status had expired in, well, not status, but status had expired in Cambridge. His license status they lost their license status. Was in the forefront.
It was more than expired. It had challenged. They were forced to shut down because of there were so many issues. They had their license. But we're not going to talk about that particular case here because they also had a location in another town. Mm-hmm. So, and that location still was operational. It still is operational. And I think, and we'll dive into some of the specific entities that benefited. We'll dive into that in a separate video clip. Mm-hmm. All right. So let's get back to this one. And here we go.
General applicant.
Where it already captured, where it has RMD license. See, this is the important thing that was kind of missed because they were also talking about locations, and it was never, of course, they wouldn't want to make a big thing about this, but the language was where they had status already. These folks.
And the other pieces, and I want to point out some of the things that we didn't capture in the first video. Is one where they already have RMD licensor status, and then secondly, for the license types. So you could have a situation where, and this does exist, where you had an entity that had a cultivation and a product manufacturing medical license to operate, and based on the way that she is reading the legislation and the way the legislation is written, these entities would have priority status for pursuing recreational cultivation and product manufacturing at the same location, not for retail because they did not have a retail medical side. That's not what happened. We'll let her continue. What you'll find is there are companies that have a medical cultivation and product manufacturing operation, and they leverage their priority status to open up retail locations, whether recreational retail locations at the same location or at other locations throughout Massachusetts. And both of those licenses that they obtained should not have been through the priority status. As she points out, it should have been through a general applicant status because it doesn't align with the legislation. So here we go. So that's what I just said. Did you follow that?
Let's pause right there. So she's just put that out there and they all agreed with her. They unanimously agreed with her that this priority status was illicit, wasn't in the legislation. Case closed.
Okay, you just gave that away, but we haven't even played that. that clip yet, that section of it. However, I'm glad you highlighted it because we don't want that to be missed and lost on the audience, which is, she said this was how she understood the law to be. And if this is the case, then there needs to be some redress for that. And so what you're going to see happen in the next clip is that she turns it over to the executive director and the chair for them to determine, is everyone in agreement that, oh, this is what the law says? Or was there some other legal perspective and interpretation that should be factored in and therefore give justification to what we saw happen in Massachusetts? So let's listen in and see what the response is.
Let's. Dead silence. Title just co-signed it. So hold on, pause right there. Now, this is the social justice chair. The social justice chair says she just agreed with Doyle's interpretation of the illicit priority status. And that's it. That's it. So
nothing else to say.
Rich, wealthy folks from out of town got the economic empowerment folks, the social justice, the victims of marijuana mass incarceration, got the social economic funds through a social economic program created in the legislation for these folks who were disenfranchised by marijuana, and the social justice chair says nothing. No advocacy. No advocacy. MRCC says nothing. No advocacy.
Just to highlight, give some context for those who don't know. When you say MRCC, that's the Massachusetts Recreational Consumer Council, an organization that has touted their support for social equity and social justice here in Massachusetts. They actually have a whole platform where they collect funding in the name of promoting and supporting that, which is a little bit of a dichotomy.
It's an advocacy group that finds its root with Chris Crane, Students for Sensible Drug Policy. Same thing with Shailene. They find their roots with Students for Sensible Drug Policy. So, and you see these groups, Students for Sensible Drug Policy, going to states and manipulating cannabis legislation after raising up these young activists from college to hoop and holler about legalization. Even though legalization is happening in that state, they want to be deemed as the people who got that state legal because they were the biggest, loudest champions crying for legalization. So this is their claim to fame. They become the muscle. They become the local muscle. Nobody can say anything against them. Nobody can contest them. Our issue was we got caught on the bad side of MRCC, this state-funded activist group at the time. They were state-funded activist group. They started to attack economic empowerment applicants, which my wife and I are. We are in the equity program. So they started to attack us and play different politics. And we saw who they were connected to. We saw who they were getting money from. We saw the deals that they were doing, the predatory deals they were a part of. And we shined a light on that. But they were a part of this. Where's the advocacy? Nobody around said anything about this illicit priority status. All of this, it's not a debate. People have been questioning and debating and asking us and talking about, oh, it wasn't illegal. There was no illegal prior. Here it is right now. They just said it. It was an illegal priority status. A priority status that they should not have gotten on the legislation. Wasn't on the legislation.
Let's continue.
Let's see what they want to do about it. Since they're all in agreement of it.
Sure, I just realized that
Nothing from the executive director. This is his show. Nothing from Collins. Nothing from Collins.
He just gave numbers. And what's interesting is
I'm confused at how he's saying that the people who would be affected will be that 34%. That doesn't make any sense to me. How is that 34% affected and not the greater percentage? It's actually the other way around is more affected. Is the 34% those who are operating and dispensing already, the RMDs who are here.
so in terms of percentage wise, the numbers probably aligning the way that you're describing. But the way he presented the data, some key things. First of all, he said it was a sample or applications that were surveyed.
Not all 70 years old.
So when he uses that word surveyed, that leads the question by October, let's say 1st of 2019, how many applications did they actually have for priority status? That's one, because he said that they were only looking at 214 applications that had been surveyed close to that time. That's the first piece. The second piece is he has honed in on the co-location piece and the licensing piece. So basically identifying which applicants had he called it a PCR or an FCR, which presumably refers to the provisional license status or final license status. And he said that there were about 170 of them that had that, and it was for a co-located space. Now, what they did not say was, is that co-located space for a medical dispensary that's operational already and dispensing? Let's just use the word operational. Is it for something that's operational? He does not go into those specifics. So it could be that someone has, during this time period, has submitted an application and said, yes, we're going to open up a medical dispensary, and they obtained the priority status. And they said, at that same location, we're going to have a retail or we're going to have some type of recreational facility going there as well. And so by the parameters that the executive director is focusing on, then yes, they are within they're within the parameters that they should be. However, to the point that you're making, that entity can then move on forward through the process and only open up the recreational side and never open up the medical side. All it says is that they have a provisional license. And when you look at the data that is available, there are numerous operations that are like that. So he completely disregards that aspect and then chooses to focus on whether or not the entity is getting priority status for separate locations.
Mm-hmm.
And that's where he focuses on the
that seems weird. They all try to.
And that's where everyone tries to say, oh, the problem is. And it is definitely a huge problem because it has implications for the impact on anyone else, general applicant, expedited applicant, economic empowerment applicants who are also supposed to have priority status. It has implications for when we are navigating the local municipalities and as economic empowerment applicants, stating that we have priority status, but then we're going up against big money that's also saying that
but
they have
the greater
priority
foul
status.
is exactly, you increase the competition of big money, big time. So I would much rather have local RMDs who are operating in dispensing in Massachusetts be able to get another location outside of their medical location, other than being our market being flooded by another 100 plus multi-state operators who each wanted to get at least three licenses apiece. And you can see the bigger issue there.
So let's see what else he has to say.
Absolutely.
Now let's listen to this. This is so funny. Press pause. This is so funny. She is speaking in slang. Like
What she just described was how the legislation was originally written. That's what she just described. And I shouldn't say the legislation. That's what the ballot was.
She said these applicants who were given medical locations who weren't operational.
Yes.
So she's merging two things. She's speaking in like a slang vernacular she just made up. Medical dispensaries who weren't operating.
So how are they a medical dispensary?
Yeah.
They should be considered dispensary applicants.
She's trying to say two things at once, trying to merge in the fact that these medical dispensaries, these medical people who got RMD status weren't RMDs, and they had locations outside of their RMD sphere because they weren't RMDs and they had no location.
Well, these are the multi-state operators.
Yeah. So it's kind of some botched up way to kind of jumble up kind of two different things and not really be clear about what you're saying, because it sounds like you're just talking about locations when you're actually talking about
the license
statuses that didn't exist. So it's really convenient how clear they like to be on certain things and just kind of like jumble some things up.
Convoluted.
Yeah.
Let's continue here.
mean change a policy that never was in the policy so we can kind of streamline the non-policy change of the policy that never existed.
Let her finish. We can hear this. Silence. Not golden in this case.
Hold up. So this is where the champion was. This is where the social justice chair is supposed to be like, well, I would like to say that this is unfair and this is the status quo that they're talking about that we wanted to avoid in Massachusetts, but here we are again, the status quo, the little guy is being left out. This priority status was for those disenfranchised with a war on drugs, and now here it is. What are we going to do about it? What do we owe these folks who are harmed by these decisions that we made to allow these folks to have priority status, to come in, have 100 plus, 200 plus, 300 HCAs. They took our HCAs because the HCAs are limited. They created a competition for HCAs where they were throwing all types of imaginary because they had the big pockets. So this is where the social justice chair, a person who's experiencing social justice, would start to have some advocacy for us, unless
would capitalize on the moment, because
unless she was a part of, unless
her agenda wasn't about advocacy for equity.
Well, she was a minority. She worked on the board for Forefront Ventures, SSDP, Chris Crane.
Well, the ties
co-founding board member.
The ties to these entities, her ties to them were extensive. However, I think as you speak specifically about her, I want to just take a step back and provide context for folks who, regardless of her, when you have a position such as a social justice, and we're talking about the time frame that we're in right now as a society where people are just kind of shocked, like, oh my goodness, I didn't realize how racist our systems are or how much white supremacy dominates. It's opportunities like this that completely go miss and over folks' heads. And when you are charged with bringing justice, you are championed. And let's be clear, this social justice chair has been championed by the Black community in Massachusetts. I'm talking, when I say Black community, even the Black and Latino Legislative Caucus here has championed her. And they championed her role for bringing equity in Massachusetts. And here it is, we have someone else on the commission talking about a priority status that was illicitly given to the status quo, to the big pocket white male owners who were able to leverage their connections with certain entities such as Forefront Ventures and Vicente Sederberg that were aware of this loophole that the CCC created. Now, whether or not it was created intentionally, accidentally, no one has said that. What Kay Doyle says in this episode, this meeting, was that she wasn't a part of the decision making. However, when she took the time to look at this and evaluated it through the lens of the number of RMDs enjoying priority status, a privilege. When you talk about enjoying, this was a privilege that was supposed to be set aside for economic empowerment certificate holders, which was one of the key levers for bringing equity in our industry.
They should have came in as general applicants.
And she's saying here that they should have came in as general applicants. Anyone who is about equity would jump up and say, thank you. Thank you, Doyle, because you have shed light on the reason why we have not been able to get traction. So let's address this, and what can we do so that our people being the people who the social justice chair is advocating for, so that my people can get the licenses and the positioning that they were supposed to have as priority applicants. That's what the social justice chair position is called for. And when we talk about people who want to champion an individual for their role in equity, we're talking about, look at the outcomes. This is why we said, look at the outcomes, because this was a key moment in our industry's development and foundation that was lost and glossed over with no advocacy for equity.
Not only that, my wife and I, we pointed it out, and she attacked us. She called us liars. She said this didn't happen. She
Yep.
didn't call Kate Doyle a liar. She didn't call Kate Doyle a liar. She sent all her media goons after us.
Yes.
The media is not talking about this. The Boston Globe is not talking about this.
Although they like to purport as though they care about Black issues, because they are quick to talk about all the negativity tied around Black lives and
They
Black
claim to
Lives
be
Matter
proponents
and
for
all this
equities,
stuff.
but they're proponents for white supremacy. They're proponents for white supremacy. The whole Cannabis Commission is white. Shailene Title is Indian woman, and she's proponent for white supremacy. She never advocates her whole. You can check out the videos. It's all about women, women, women. And when you're saying women, that's code for white women. That's not minorities. Minorities is said. Minorities covers women. Minorities covers LGBTQ.
It covers veterans. It
Covers veterans.
Every other category. Just to further provide context, if this is the first video you've seen of ours, the Economic Empowerment Program provided priority status to 122 entities or applicants across the state of Massachusetts. And of these 122 entities, approximately 85% of them are minority owned, and that minority falling under the category of Black or Latino, because that was one of the criteria that you could use to qualify to obtain this status, one of 3 that you needed to meet. And so 85% of those 123 applicant economic empowerment certificate holders are Black or Latino. So this is a large population of people who, one, have demonstrated the business acumen to support communities and promote empowerment economically in these communities, and 2, demonstrated an interest in wanting to open up a cannabis establishment here in Massachusetts. And as a social justice chair, your role, these people fall under your purview in terms of who you need to be advocating for. That's where the equity is coming from. This was one of the equity provisions that Massachusetts has embedded in their legislation, and no advocacy whatsoever. The other piece I want to highlight, because we're going to continue playing the video clip, is the social justice chair does speak up, but not on this matter, on another matter right after this. The issue she brings to the table that she feels is so important is the need to have economic empowerment people be able to decipher what is a bad deal, because we don't want them to fall prey to predatory lending, which definitely exists across in any industry. But that is the extent to her advocacy and support for economic empowerment.
I mean, it's the slander we had to deal with. It's the rhetoric it's the ugly rhetoric we had to deal with for the first 3 years, while they were backdooring these multi-million billionaires from out of state and out of the country. They were waving us in the public space like, I don't know why they can't get in. These people are incompetent. Oh, watch out, these people are taking bad deals. Just a whole bunch of rumors and negativity inflamed by the Boston Globe, but nothing positive, nothing strong, just about how ignorant we were. But we're not too ignorant to see this. But where's this at? How come nobody's talking about this? But we had to endure slander and libel, but so they can do this. They fanned us in front of the public so they could do this.
So let me bring this back up and continue this.
There it is again. There it is again. It's spelled out right there. She requests that. I don't even understand what his job is. Like, is this your job to see this or to notice or to direct this? Is this Colin's job to direct this show, or is it? So why, like?
Yes.
He should have called it out. Shailene should have called it out. Who should have called it out? Like, how did this even start? Like, that's what I want to know. How did this even start? Who, like, okay, this is a $1 billion oops. This oops lifted an entire cannabis economy into the pockets of a few out-of-state folks, not Massachusetts residents. It created a bottleneck where these companies, Vicente Sederberg and Forefront Ventures, who wrote on our legislation, made hundreds of millions in Massachusetts.
So it's clear so they can see you.
How is this ethical? How is this ethical? And nobody is saying anything. And Collins right now, we got a freeze frame. He scratching his head. You know? And who gets the economic repercussion for this? Boo-boo. You know, how do we make these economic empowerment program certificate holders whole? Because you forced us into these, my wife and I, we're not public people. Now we are. You forced us to be advocates. You forced us to be public people. You fanned us in front of the public so you can kamikaze us. This was a whole smokescreen. To the Massachusetts residents, it was a smokescreen. Hold up, Massachusetts residents. You can't get into the cannabis industry right now because we have to get these economic empowerment folks into the cannabis industry, and we don't know what's taking them so long.
It's capital. HCAs, they have barriers. They have
and this whole time,
we can't do nothing about.
How does all of these licenses, 300 plus licenses, get approved and nobody says nothing? The social justice chair is quiet. MRCC quiet. They just getting on the PIPs. MRCC getting the PIP money. They quiet. Getting the state funds. They was quiet.
Well, they weren't quiet. They were quiet about what was happening to economic.
They were quiet about this.
When it came to this,
they were actively slandering us.
At the time, in the media and in their online communications, campaigns, etc. So this conversation, as you said, you know, this was $1 billion oops, and I think that's a proper context because it's a oops that doesn't have ramifications just in that isolated time frame. It had ramifications prior to those who were affected for the 590 days.
These folks.
You didn't want to hear what I had to say?
I'm sorry, but I just had to say it, baby queen. I'm sorry. I'm gonna cut you. I'm gonna let you finish when you finish. Now, these folks was so sorry for the oops. My wife and I pointed it out, and they sent a threat letter to us, talking about coming to arrest us and threatening us with suitability, threatening us with not being able to or operate a cannabis license. Because we pointed this out. Because we were like, what happened to our priority status? And we like, oh, there it went.
That's exactly.
And they sent a threat letter to talking about police. In this time, talking about sending local police to our house.
Given the context now, we're talking about this letter came to us, I think, at the end of August 2020, when in the height of everyone in this nation talking about the stigma and the challenges in terms of police relations with the Black community, in the height of George Floyd. Now,
the reason why we in the equity programs is because they talking about sorry for the war on drugs. So we in the equity programs because they said, we got to do something for Black and brown folks because sorry for the war on drugs. Sorry for the over-policing. Sorry for the police terrorism. Sorry for the using the police as like a war against you because of your skin color.
Reinforcement.
And now here they are using the police again.
Doing exactly what...
For activism. So they call it harassment. So for the same thing that white folks is activism, when Black folks do it, it's harassment. And they're going to use their power. They're going to use their power like thugs. Now, these same folks right here, I wish they was that aggressive with these multi-state operators or this aggressive with this situation. Yep. Why they didn't send a suitability letter to every single last one of them? Like, you know what? The priority status we gave you was illicit. Here's you on suitability. We need you to tighten up and shape ship around here in Massachusetts. And this is what we need you to do. Cynthia Monpoint wrote a program called the PIES program. Here you go. This is what you're going to do. They real thuggery when it comes to the folks who ain't got no money, like my wife and I, who ain't got no power. They black folks. If we was white, they would have, hey, come on in, come on in. We would have been invited in. Because we black, they took a hard stance against us, talking about they going to sick police on us.
I want to push that a little bit, because we're black and we're vocal about the injustice, because there are plenty of, they're going to find the black folks who will do the dance for them, who will say, oh, well, you know, yeah.
Of course.
We're not like them. We're not upset about that.
Of course, but when white folks are vocal about injustice, it's called activism. We've been vocal about the injustice, or we've actually contacted these guys privately, actually. You know, we've contacted them privately to handle this matter privately with a program we wrote called the PIES program. You can go check it out at massmothermary.com. We wrote my wife wrote the Massachusetts Marijuana Social Equity Report. You know, this was our response. This was our response, an intelligible response. You understand me? We've been treated with nothing but thuggery by them. They're going to sick the police at us, but they show no aggression toward this matter. No aggression, no advocacy. The social justice chair, you would think she would be singing our high praises for writing the report, for pointing this out. Maybe she's scared to lose her job. I don't know, but we pointed out, and she sends her thugs after us. She publicly calls us liars. Collins sends police after us.
That's their solution. That was their written, documented response, not the communication that what's his name?
Right after we got out of a meeting with Hoffman.
Now, for those who don't know, Hoffman, you say Collins. Collins is the executive director for the commission, basically oversees the commissioners. That's who they answer to. Hoffman is the chair of the 5 commissioners. Well, now it's 4. And we had just, I think, a week prior to receiving this letter, we had just had what we would deem a productive conversation with Hoffman about what we saw as a problem in Massachusetts with the cannabis industry and how we could move forward. He had the opportunity to look at the Massachusetts Marijuana Social Equity Report. He provided a brief commentary on that in our meeting. He had the opportunity to look at the PIES program. And his response about the PIES program was like, well, it makes sense. And it aligned, but because it aligns with the positive impact plans, and the call is to hold the entities who are raking in the revenue here in Massachusetts accountable for their role in supporting and promoting promoting equity here in Massachusetts. And to the point that you shared, and the fact that there was a big oops that happened, and this would at least allow for some amelioration for that oops, we would be able to see an increase of anywhere from 18 to 20% in ownership. Diversity in ownership, minority ownership here in Massachusetts, just by implementing the PIES program. And, you know, when you look at it from that perspective, and in our conversation, he had nothing negative to say about the program. He had some questions about how would we move forward, et cetera. And we provided responses to that made sense. And we ended that conversation with, okay, we'll continue this conversation. What happened was, this was a private conversation, and then the CCC had their regulatory period open up, and the Cannabis Advisory Board, who we also presented the PIES program, brought the PIES program to the public in a way that we have not been able to reach the public, the same audience, because these are a lot of folks who follow what are the regulatory changes. And here the Cannabis Advisory Board brought PIES out to the public. And now people who would not normally be asking about PIES are contacting the CCC, asking them about PIES. And that put the CCC in a tight situation, I guess, if you would, for lack of a better word, they had to now answer for a program that they just were going to let slide and pass, maybe assuage us, but with conversations, private conversations, but never get this to the point up to before the public, before different businesses who could actually be affected by this, who could participate in this, who could support this, who could push this. And now that is happening. And so the response,
which, by the way, the local businesses, the local RMDs or MSOs seem to be in favor of it. Every MSO we spoke to seemed to be in favor of our pilots.
Not only do they seem to be in favor, and part of the reason why they seem to be in favor is because it would be more structured than the individual programs that they have erected, in their I guess in silo instances, isolated instances. So this would be something that would be at Massachusetts as a whole that we would be implementing, and this would be Massachusetts' model for how do you effectuate equity in the cannabis industry, and in a way that bridges relationships between the big guys, those who capitalized on the oops, and those who should be in this industry.
And I think it's a strong statement. The narrative is they like to say this side lacks intelligence, I guess. The side who they are helping. We couldn't possibly know how to help ourselves. So this program was created by equity program participants. This problem was identified by equity program participants.
Says, hey, this is the help that we need. And this is how you can help us. And this is how we can work together.
And it wouldn't cost the state anything. How long has this been going? Let's try to respect time, right?
Yeah, it's about to be 1 hour and 3 minutes. So.
Okay, do we go through the whole video? No, let's go through the whole video.
Let's wrap up that video. So what I'm going to do is close this out, bring it up over here. Right there.
So that's a public admittance. Oh, Hoffman said nay?
He said nay.
He said this didn't happen.
He said this didn't happen. So hold on a second. I want to see if I can. No, that's not what I want to do. Bring this back up. Yeah, well, does that help at all? Not really. So the vote was on the recommendation that Doyle put right before we went on our little break, but basically saying that they go back to April 2018, and 4 out of the 5 commissioners, because at the time
we're gonna be hurt without Doyle. We go because she is background in policy, legal, lawyers. I guess the majority of them are lawyers, right?
Yes, all 4 of the 3 of the women there are lawyers, attorneys, and Flanagan has a public. She used to be a senator, I think, senator or state rep.
Well, so Doyle was the strongest.
Political background.
Doyle was the strongest we have. Obviously, Hoffman just vote how he feel, like whatever. White supremacy.
Well, so and Hoffman he's a strategist when it comes to businesses. That's his background, and he may have analyzed what she said and the implications that it has to any businesses that he's had the privilege of having conversations with. So that could be why he said, well, wait a minute. But to articulate that in this type of setting would not fare well with the public. He doesn't express why he said nay. No one was asking that.
So just to make sure I'm understanding what you're proposing. So they secured their initial goal. Because I mean, this is more how
What is not made clear is when she says they secured their initial priority review. How did they secure it? How did they secure their initial priority review? Is it because that they met the legislative mandate for priority status, or is it because they paid the fees to say that they're applying for a medical license? And so that's how they were able to secure the priority status to then be reviewed to obtain a provisional license. And then now they can submit their application for a recreational space license and exercise the priority status there. I'll let them continue.
how they are. So if you receive a number of applications that are resubmissions, you sort the priority categories up for them, and then they are reviewed first before the remaining. But if they already, and if I'm listening clearly, you represented that all the agencies have received. So if we are giving them all still maintaining the initial.
That's not what she asked. What she asked is, when these guys come up for a review, how do they still maintain priority status? If we've discovered that this priority status wasn't in the legislation, when they come up for a review, do they still maintain priority status? What is the use of this vote? Which I think is a really strong ask.
And to say that because from the initial review, they had priority status, and so now that they have to continue with that, that's actually not necessarily, you could go either way. You could say, well, they had it for priority. They should not have had it, for the initial review. They should not have had it. So for any other reviews, for any resubmissions, when they say resubmissions, what ends up happening is for the process, you submit your application, the CCC reviews it. If there are any questions, so they call it an RFI, they will send out a request for additional information from that entity. And so it sounds as if that they had a handful of applications that were sitting in queue, needing to resubmit information. And based on how Doyle broke it down, and Collins, the executive director, confirmed, when that resubmission happens, that entity, if it has priority status, gets bumped to the top of the list for review. And at this point, after identifying that these people should not have had priority status, that process should not continue. However, that's not the focus, as you pointed out. Collins goes on to say something different. He goes on to say that there are priority applicants who may not have gone through the initial review. Well, the question is, how can that be if they should have been identified since April 2018?
Pause. Why they keep saying that? You see that slang? For a location that was not an existing medical. So right there, it puts local RMDs and MSOs in the same box because it says a location that was not existing medical. How can you have a location that was not existing medical when the location that the medical is trying to get
no, he's
is
talking,
RMD?
this is the
I mean,
co-location piece. So what he's talking about is a
Yeah,
distinction. So for instance,
Adult.
if you submit an application, let's say I have been operating in, in the city of Boston, and I submitted an application for a dispensary in the city of Andover. If that's
for a rec.
For a rec, so that should not get priority status because it's not in the same location.
But you hear what he's saying? He's saying, so they're submitting an additional location for a rec, not an additional location for a medical. A pre-existing medical with a pre-existing location is not trying to get another location for medical. They're trying to get a location for rec.
Right.
So why are they saying a medical location? Why are they calling it these recreational locations not existing, which would only go for or qualify for our MSOs who didn't have a medical location? They're saying these, instead of adult use locations or rec locations, they're still calling them these co-located medical locations.
Let's let him finish.
I'm trying to figure out how many applicants we have in the universe that may have PCR, PCR as are potentially
Now I don't understand why. Now she's saying it, the universe. He's saying it, the universe. It's just Massachusetts. You know what I'm saying? So it's not that big, y'all. It's not the universe, Collins. I gotta figure out the universe, and it's just Massachusetts. You understand me? How many in the universe got this? It's just Massachusetts. You understand me? So I don't know what is the reason for trying to make it that big.
And for him to say that they don't know, perhaps he meant based on they hadn't done their subtraction for that moment. We're going to play the rest of the video to make it clear. However, even if we go with the incorrect number, the CCC did issue a press release in May of 2019 where they were very clear as to who qualified for priority status. They said there was 122 that qualified under the economic empowerment priority, and there were 82 that qualified under the RMD MTC priority. So to answer her question right now, the question would be, well, it can't be more than 82, and we could identify who they are. But that's not what Colin's response is. Let's play.
How do they know there's nobody coming in the future? Is that, because these guys have figured out another method to come in other than illegal priority status? Like, how do they know this? How does she know? Okay.
So technically, they should know. Why is it technically? Let's go back to, if they said there were 82 and your authorization for a license to exercise your priority status, of those 82 RMDs, MTCs, they should know which entities had what licenses already qualifying. So they should know that you have the full integration qualifying, so you can apply for up to 3 adult use recreational licenses for your current location. They should know that for all 82 of those entities. They should be able, their way that they should be able to analyze the data and give that number. So they would be able to tell you maximum what it is that at any given time, that number of licenses that would be issued under the RMD priority status. That is known. We can do that calculation. And so for them to say that they don't know, there might have been a medical dispensary that is licensed and operational and in good standing with DPH, but they had not submitted an application to open up adult use side at their existing location. Now, the reason why that doesn't matter in the context of equity is because we're not competing for that space. You already have control as a medical operation of that location. You already have control of that space. At most, if there was a limit on the number of host community agreements in a specific town, we already knew that you likely would be taking up one of those. And so all of this data could have been presented if things were done in alignment with the legislation in a way that people could break it down easily and say, these are the number of licenses we expect to see come through the RMD priority status. It's not something that's nebulous, uncalculable. They actually could do that. However, that's not what we saw happen. What we saw happen were a bunch of operators emerge who were not qualified based on legislation and capitalize on this priority status. And now the numbers, if they had done the original analysis, their numbers would not align. It would show that they have given not only licenses, but the priority status for all of these licenses illegally to these entities.
Could still avail themselves of the priority approach.
Once we identify the applicants who this would affect, can we circulate that information to the city?
The applicants, like, yo, the social justice chair is mute. Everybody asking for stuff. Kay Doyle asking for this illicit priority to stop. Britt just asked for, hey, can we get the data so we can see who was affected by this? Why isn't the social justice chair asking on our behalf? Can we get the data to see how economic empowerment peoples was disenfranchised by this? Why isn't she like turning red in the face like, yo, this is absurd. This is absurd. You understand? Why isn't she like, where's the advocacy? Because she was in Cambridge talking about equity first.
Yep. During this same time period.
During the same exact time period, her and MRCC talking about equity first in Cambridge. Equity first, equity first. Called us all types of names.
And equity first is exactly what it should have been. And it's not equity first when it's convenient for you. It's equity first across the state of Massachusetts, because that was the messaging that was going out to the public. However, the only place we saw a stance for some type of equity first and challenge with a voice from the commission was in Cambridge. I don't even know if they showed up in Boston for this, for when Boston was rolling out their equity ordinances and going through the throes as to how that would look.
And 3 years later.
Here it is at every single meeting and no one could challenge you, because you could always go back and stand on, look, this is the seat I sit in. So this is the voice that I bring. This is the angle that I'm looking at this. This is the perspective that I have to analyze our actions and decisions. And that's what should be taking place. It's in the legislation that we needed someone with social justice experience. Why? Because we needed that voice there. And instead, what we have is an individual who capitalized on the opportunity, which always seems to happen with Black people. And when we're fighting for rights, you can go back to the civil rights movement. You can go back to the women's rights movement. It always happens where they will ride the backs of Black folks, the suffering, the injustices that we have endured. And in the name of that, push an agenda. And when it comes time to say, hey, wait a minute, we're supposed to be benefiting from this agenda, it's get in the back seat, be quiet, be nice, be respectful. You're not, you're attacking us. You're harassing us.
They sick police on us. You're not being civil.
You're not being civil. You're not doing this the way you're supposed to. And it's like, wait a minute, I thought this was about the injustices that we endured. And what I'm telling you is that what's happening right now is perpetuating that. And here it is. We called and said that we wanted a chair, a position to ensure that that doesn't happen. And instead, it's silence.
Pay a lobbyist. We go pay a lobbyist. She tell the lobbyist not to work with us. Pay a lobbyist. So
we're gonna do a live on that one, because we've been on for an hour and 15 minutes. That's a whole nother conversation.
Yeah, but here it is. You're supposed to be a social justice proponent, but you creating more barriers. Then we do the avenue you say, we pay a lobbyist, we pay this individual, and you go tell this individual not to work with us. They're not viable, don't work with them. But is that the end of this?
Yes,
social justice shit.
Oh, hold on a second. Let me just give a little zoom in on us for a quick second. So what you're going to see now is the transition. The CCC has wrapped up the conversation around the illegal priority status. The vote was made 4-1. The vote was made to say that this priority status was illegal and it needed to revert back to April 2018, with McBride adding the caveat that she would like to know were the applicants affected by this, but no one asked anything as to what would be done or how, what analysis even would be done on behalf of the implications of this on economic empowerment.
For the people who were supposed to get this status.
The people who had the status and who
supposed to
were not enjoying it the way the RMDs were enjoying it. No one says anything about that. What we do here, though, is a transition to the next topic, which is being brought to the commission as valuable and information and on behalf of equity in Massachusetts.
So this commission, agency-wise, has made significant and consistent progress with our recent decision determination towards our mandate to remove businesses, communities,
So hold on, pause it. So first of all, don't ever bring up no problem if you ain't got no solutions. That's one. Don't bring up no problem if you got no solution, because that's complaining. So one, you bring up a problem, you ain't got no solutions. Two, it's inflammatory. It's bogus, it's bullshit. It's inflammatory. It was the rhetoric passed around that we had to deal from the public.
I think
Anybody,
not I think the Globe had spent a year with a series highlighting this.
Any of these affluential businesses, cannabis operators who are operating in Massachusetts that were seen with the EE, an equity participant, the rhetoric, the stigma was that these people are getting taken advantage of. Nobody knew the deals, but that was the rhetoric. And here it is, she's pushing gossip, rhetoric, and it has no solution for it. This was the rhetoric they pushed in Cambridge.
And because when just to give an example, the entire time when I listened to this, the first time I heard this video clip, and I said, so the concern is we don't want our economic empowerment certificate holders who we want to be successful business owners in this industry. We don't want them to be taken advantage of. And our solution is to put out a document, not to provide technical assistance, which you could have done, but you said you weren't going to do, not to reach out to any of the legal teams, the legal experts, et cetera, that would be able and offer the opportunity to have contracts reviewed and weighed in on, and so that you could have another opinion if necessary. If you didn't have an attorney representing you, if you didn't think to have some form of representation and reviewing of contracts that you entered into, then this would be the solution to assist that. But the solution was to put a document, which ends up, I should have had it up to show. It's a one-page document that I think would be great to give like 7th graders in terms of introducing them to the concept.
But it's almost like that. It's almost like, oh, I have something I can say. There's predatory things going on with the active. Hold up. We just spoke about the Colorado heist, the cannabis heist in Massachusetts. $100 millions of dollars, $1 billion heist, cannabis heist, a whole cannabis economy, economic espionage. And she talking about, I know what to say. Let's talk about this. Almost like a 7th grader. I don't see, it wasn't on that level. It just wasn't on that level, and you had no solutions.
And again, just kind of going back to, we're pointing out the problem, and we already have drafted a solution that we provided the commission 5-6 months ago. And we also presented it, and it has been circulated, and folks are aware of this. And it's a solution that is outcome-based. What is that? What does outcome-based mean? Well, when we say that you want folks to have priority status, but then you know that there are barriers that exist for people to even exercise that priority. I mean, these are the images that they put on the CCC's equity page, where they talk about equity and the war on drugs and et cetera, and they recognize certain key barriers. We've addressed all of those barriers to ensure that the product When we look at the data, it will reflect the equity, not just the rhetoric on the front end, but on the back end, on the result and the data. The analysis that we do will reflect the equity that we say we want to see happening in Massachusetts. And the stance by the commission is, it's not even silence. It's, we are going to attack the people that brought this solution.
It's straight aggression. They've been aggressive. You talking about sicking police on Black folks? You hoping they shoot me? You hoping they think my cell phone is a gun or something?
Why else would your solution be to engage law enforcement? For what? Engage law enforcement to do what?
Just because you can? I mean, I'm trying to wait for you to be like that with these folks, with all these folks who got this illicit priority status that you guys seem to be so passive about and so aggressive with us. But that's the children, so the cues.
That is definitely the cue. We're gonna wrap this video up, and yeah, this one was actually quite long considering the way we structured it. So with that, let's go ahead. I'm gonna stop the screen here and end the broadcast.
Thank you for joining us.